Very good evening, students. Good evening, everyone. Any volunteer, please confirm about the voice and the video. Chaliye. So, first of all, I welcome each one of you to my class on the introduction of Code of Criminal Procedure. Very good evening, Vishal. Thank you for the confirmation. On that note, let's begin with the session. So, first of all, let's start with my brief introduction. My name is Sandeep Khatri. My areas of specializations are the constitutional law, criminal laws, commercial laws, family law, jurisprudence, and law of torts. Students, I have shared the link of my profile of Unacademy, so please make sure that you follow that to get all the updates about my special classes and my plus courses. I have also shared the link of my Telegram channel where you can connect with me and ask questions in related to your judicial preparation. At last, I have mentioned my code, that is Khatri10, which you can use to get free access of all the special classes available on Unacademy app, and also to get 10% discount for all the Unacademy plus courses. So this was about me. Now I request everyone, please be attentive, and this is going to be interactive session. So in this particular class, we are going to discuss about basically the introduction of the CRPC. So before starting the introduction, if you have any questions in your mind, you may ask, and if not, then quickly give me a thumbs up. I'll start with the introduction. Namaste Agarwal ji. Very good evening. Alaiva, Sakshi, very good evening. Okay, I guess everyone has already joined. So let's begin with the introduction class. So when it comes to the introduction of this subject, the very first two questions that comes into my mind is, the first one is the meaning, and the second one is jurisprudential essence of CRPC. So these are basically the two most important questions, that what do we mean by this term CRPC and what is the overall objective of this code. So let's start with the meaning first. So in the meaning itself, the first thing which you need to know is that it's a criminal law. When we say this term criminal law, so the major criminal law for a judicial aspirant is, the first one is your Indian Penal Code, that is IPC, which is a substantive law. Then there is Indian Evidence Act, which is basically an adjective law. And finally, that's a CRPC, that is your criminal law, which is basically your Code of Criminal Procedure. So CRPC is basically giving you the procedure. The key term which you need to focus on is the term procedure. So what kind of procedure we are going to deal with? So it's a procedural law. So there are basically, when it comes to the classification, there are two types of law. One is your substantive law, one is your procedural law. So on one hand, when IPC is a substantive law, on the other hand, the CRPC is a procedural law. Now, when it comes to procedural law, what kind of procedure we are talking about? So let's understand the whole concept, the meaning and the objective of CRPC with a simple example. Now let's take an example, students. If there is a person, Mr. A, and he shot down Mr. B. Now in that case, Mr. B died. Now the first question in this illustration arises, what offense has been committed by Mr. A? Whether this is a murder or culpable homicide or any other offenses. So the answer lies in Indian Penal Code. So IPC tells you that Mr. A has committed the offense of murder. So murder under section 300. So Mr. A will now get punishment under section 302. 302 is punishment for murder. But now the question is, how Mr. A will get that punishment? What is the procedure which we are going to follow so that we can convict Mr. A, that it is Mr. A only who has committed this offense? Now the answer of this question lies in CRPC, students. So what is that answer? The answer is, first, there is going to be FIR. I'm just giving you one simple example of procedure, that what overall procedure is going to be followed up. So the first step, lodging of FIR. After lodging of FIR, there is going to be investigation. After investigation, there is going to be police report submitted by police. Then the magistrate will take cognizance. After cognizance, there is going to be issue of process. After issue of process, there is going to be the concept of charge. And finally, there is the concept of trial. And in that trial, the Mr. A will be convicted. So this is the procedure that has been given by the subject, that is CRPC. This is just there can be three ways that criminal law can be come into motion. One is because of the FIR. So I have given you the most common procedure followed because of CRPC, and that is this one. So this is what CRPC is. CRPC is giving you the procedure. IPC is telling you what particular offense has been committed, and after that, this is the procedure that has been given by CRPC. Now I'm just having a look onto your comments. If you have any questions till now, you may ask. Yes, Vivek, you can start your preparation within the first semester as well. Okay. There is no there is no foundation on that. Shiv Gauri, very good evening. Hi, Dharam Raj. Okay. There are no questions, so I'm continuing with this. So now coming to, if this is CRPC, what is the jurisprudential essence? Why do we need CRPC? So let's take the same example. If offense has taken place and if we don't have CRPC, can IPC punish someone? The answer is no. Which means, so basically IPC and CRPC complement each other. If there is no CRPC, you cannot convict that person. If there is no IPC, you cannot give the punishment. So they basically complete each other. IPC in combination with CRPC completes the criminal law. So when it comes to CRPC, now there is the next question. Who all are the functionaries of CRPC? To whom we are going to talk about. So what are the functionaries of CRPC? Coming to the next question. Who all are the functionaries of CRPC? So there is a list again. The first one we are going to talk about is the victim. So who is the victim? The person against whom the offense has taken place. That is the person, we call him victim. The second one, we call him accused. The person who has been accused for the offense, that you are the one who has committed the offense. Now the third one, that is the court. Which one are the criminal courts? So court of session. That. So as per to section number 6, which court are going to be the criminal courts? Answer in the comments. As per to section number 6, which 4 are the criminal courts? Without looking into your bare X, this is one of the most important question for your PT examination. Which one is a criminal court as per to section number 6? Very good evening, Dharam Raj. Students, answer to this question. There are 4 types of your criminal courts. The first one is court of session. Yes, I have not received even a single answer till now. Court of session, judicial magistrate first class, judicial magistrate second class, and executive magistrates. So these are the basic, the most important courts which we are going to talk about. all are the criminal codes. Okay. Okay. Moving forward. Now, who else? After that, we are going to talk about the police as well. There is going to be the role of police while doing arrest and while doing investigation. What is going to be the role of court? The court is going to take the trial. Okay, ji? Now, what the police is going to do? The arrest, that is basically starting from your section 41 till section number 60A. Then what are the powers of police? When the police may arrest, then there comes the role of what are the duties of a police officer while doing the arrest. What are the rights of arrested person? After that, the role of investigation. Section number 2, clause H, define the term investigation. What is the purpose of investigation? To collect the evidences. Where the investigation starts from section 154 till 173. These are the most important section in relation to the concept of investigation. Then who else is the functionaries of CRPC? That is public prosecutor. When it comes to offense, offense is against the state. So that is why, let's take an example. If an offense has taken place in UP, that's why the citation is state of UP versus Mr. A, the name of the accused. Now, why state? Who is going to represent the state? Who is going to do the prosecution? That is the public prosecutor. Then there comes the next one is your defense counsel. And the last one is going to be your witness. So these all are the functionaries of CRPC, which we are going to talk about. Defense counsel, the advocate of the accused, who is going to defend him. And the witnesses is going to be on both the sides, whether it is from the prosecution or from the defense. So these all are the functionaries of the CRPC. So till now we have done 3 questions. What is the meaning of CRPC? What is the objective, or you can say the jurisprudential essence of CRPC? And the third one is what are the functionaries of CRPC we are going to talk about. Any questions from these 3? Anyone? Okay, I have got one question. Executive magistrate also under criminal codes. Okay, now let me answer that. Students, when you will go, right now, you are going to read CRPC 1973. When you will go into the history, which means before 1973, you will reach that there was CRPC 1898. Now coming to what is one of the major change that has come between CRPC 1973 and CRPC 1898. There were 5 major changes, but the one which I am going to talk about is the question itself from Sumati Success Channel, and that is of executive magistrate. So, executive magistrate is completely different from judicial magistrate. Now, who is the executive magistrate? Executive magistrate is basically the collector, okay, the district magistrate. Now, the role of executive magistrate is to prevent the offenses. To prevent the offenses, that the offenses should not take place in his particular district. Okay? That is the objective of the executive magistrate. When it comes to the judicial magistrate, so once the offense has taken place, now who has committed that offense and what kind of punishment he will be given to, then the role comes to the judicial magistrate, which means after offense, it is the role of judicial magistrate. So there are complete 2 different roles. Right now, you all are judicial aspirants, so you want to be a judicial magistrate. If someone is writing for, you suppose if you are preparing for UPSC exam, right? Then in that case, you are preparing for yourself for the executive magistrate. So this is the difference. Okay. I hope I have answered your question, Sumati. Any questions till now? If it is all clear, quickly give me a thumbs up. I'll move to the next one. Okay, you're welcome, Sumati. Now, coming to the next question. Who drafted CRPC? So the answer is, so now we are coming to the next question. Who drafted CRPC? So the answer is, it was the 41st Law Commission that drafted CRPC. Now coming to, what were the three major points? What were the three major points which were in the minds of the drafters while drafting CRPC? So what they were thinking about. So the first one is fair trial. And when it comes to the concept of fair trial, it doesn't means, generally there is a rumor, there is a myth in the minds of judicial aspirants that whenever it is conviction, it is justice. No, it is not like that. Free trial means if that is an accused, he should get an opportunity to represent his case. He should get all the opportunities to defend himself. On the other hand, when it comes to the victim also, his story should be represented to the court by public prosecutor. So both should get justice in a form that there should be fair trial, fair opportunities to both the parties. Coming to the next one, that is the simple procedure. The second thing that was in the mind of the drafters while drafting CRPC was it should not be complicated. It should be easy process. So it should not be complicated. And now coming to the third and the last point that was in the mind of the drafters was avoid delay. Now, what is the concept of avoid delay? You must have heard about that maxim that justice delayed, justice denied. When you will look into the amendments of CRPC, there is one objective of all the amendments that the procedure must be fast. It must be fast enough that the parties, the victim, the family of the victim should, realize that, okay, if the offense has taken place, we have already got the justice. And that is only can be a possibility when you are going to avoid delays. There should not be adjournments. So these were the three major points that were in the minds of drafters while drafting CRPC. Fair trial, it should not be complicated. When you are going to read the trials, there are four types of trial. Court of session trial, then there is warrant case trial, then there is a summon case trial, then there is a summary trial. The procedure is so simple. It's not that complicated. Okay, if you read CRPC with some practical examples, it is going to be a very, very easy and relatable subject. Okay, so these were the three major changes. These were the three important points that were in the minds of drafters. If it is clear, quickly give me a thumbs up. I'll move to the next one. If you have any questions in your mind in relation to these concepts, feel free to ask questions in the comments. And if it's all clear, quickly give me a thumbs up. Waiting for your thumbs ups. Okay, no questions? Sumati, I've got your question. Who drafted? So there was a commission that has been set up in 1955. Okay. That was basically the 41st Law Commission that drafted CRPC. Okay. And they have basically studied the old code exclusively. And after that, the report submitted in 1969. And finally, we got the Code of Criminal Procedure in 1973. Done. Very good evening, Neha. Okay. Moving to the next question. The next question is what were the five major changes? Which one are the five major changes that has been brought in CRPC 1973? So the first one is no third class judicial magistrate. Just a second. No judicial magistrate third class. So when you will read CRPC 1973, you will not find any role of judicial magistrate third class. Okay. Second, no jury trial. So as per to CRPC 1898, there was concept of jury trial as well. So what was jury trial? So basically there were 10 to 12 respectable members of the society, and they also do hear the case, they also do hear the witnesses, and they also used to give their judgment, which was of the equal importance, and that usually impact the decision of the judge. So but after okay, which one was the last case in which jury trial was taken place? Anyone? You all must have read about that case. It's a landmark judgment. Anyone can recall which one was the last case where jury trial took place? Yes. In IPC, you must have read it in right of private defense as well, and in section 300 exception 1 as well. Yes, now I can expect the answer. KM Nanavati versus State of Maharashtra is the correct answer, Sunita. Yes. So that was the last case where jury trial, took place. So these were the major changes. Now coming to the third one. The third one is the introduction of summary trial. So there was no concept of summary trial before CRPC 1973. Why not? So why do we need the concept of summary trial? So let's take an example. If there is a person who is traveling uh, without ticket, so his trial should not be mixed up with someone who has committed an offense of robbery. Okay, so there must be some major differences in the trial. Okay, so when basically it's a petty issue, so that must be disposable of the cases on the first hearing. Okay, so that's why we introduced the concept of summary trial. So this was one of the major changes, and that is why it is one of the most important topic for your exam as well. Coming to the next one, which one is the fourth one? That is the free legal aid. Now, why do we need the concept of free legal aid? So suppose if the victim comes from a background who is not financially very well, so in that case there is a concept of free legal aid to everyone. Okay, it's not something that justice is not something which you can buy. Okay, this is something which is your basically the right. So whosoever you are, there is a concept of free legal aid for that. Okay ji? Now coming to the fifth major change that has taken place, and that is differentiate judicial magistrate and executive magistrate. Now, after going through with CRPC 1973, you can easily figure it out this that the role is well defined. Okay. Now, when it comes to keeping security for keeping peace, there is complete role of executive magistrate. When it comes to section 144, there is a role of executive magistrate. But when it comes to taking confession under section 164, there is a role of judicial magistrate. Now let me ask one important question to each one of you. Suppose if you are reading a section, okay, and there a term magistrate has been used. So which magistrate we are talking about? Judicial magistrate or executive magistrate in that case? I'm repeating myself. A simple question. If you are reading a provision and they have in that particular provision they have not mentioned that we are whether we are dealing with judicial magistrate or executive magistrate. They are simply writing magistrate. So what they are referring to, judicial magistrate or executive magistrate? Answer in the comments. Sumati, both. Okay. What about others? Okay. Sunita took reference from section 3, judicial magistrate. Correct answer, Sunita. Sumati, please do correct yourself. In that case, we will consider that as a judicial magistrate and not executive magistrate. Now coming to the reasoning, why so? Because of your section number 3. If you go through with the reading of the bare reading of section number 3, that's the simply the conclusion is if only magistrate has been written, then the answer is going to be judicial magistrate. Okay. If I can give you an example of that as well. So you may refer section number 3 for that. So these were the 5 major changes that has taken place. Students, you always, you know the concept of amendment, okay? So we do come up with certain amendments. Like for example, the last important criminal amendment was the 2018 one. Okay? Now coming to when there are going to be, see, law is going to change as society is going to change, right? So there are going to be amendments. But when we repeal the whole code and come up with a new, complete new code, so the reason is the changes were huge. And these were the 5 major changes. Because of that, we have to introduce the complete new CRPC. Okay, so these were the 5 major changes. If it is clear, quickly give me a thumbs up. If you have any questions relating to this, please feel free to ask questions. Very good evening, Ikra, and everyone, those of you who have just joined. Yes, please, any questions? If all clear, quickly give me a thumbs up. I'll move to the next one. Okay, moving to the next topic in the introduction itself. Now there is one important question which we need to discuss in the introduction class as well. How criminal law can come into motion. Let's first understand the question only. Let's first understand this question only. Everyone, please be attentive. Okay? All eyes on the screen. How criminal law. So basically, when I say how criminal law, I'm talking about how IPC, how CRPC, how Indian Evidence Act, or any special criminal law. Okay? How that criminal law can come into motion. Come into motion in the sense, okay, let's take a simple example to understand this question. If there is Mr. A and he committed the offense of murder, and he committed the offense of murder against B. Okay. Now B is dead. Now the question is, when it comes to the functionaries of CRPC, which I have already discussed in this class only, so how the police got activated, how the courts will get to know about this, how the magistrate will get to know about this. how the victim, how the family of the victim will get to know about this, which means how this whole criminal law will come into the motion. Ki, okay, IPC will say ki, okay, there is a role of section 302. CRPC will say, okay, court of session will do the trial. Judicial magistrate first class will take the cognizance. Indian Evidence Act. Okay, who can be the witness? Mr. C is the eyewitness. So as per to section 118, he is going to be the eyewitness. Now the question is, we do have the concepts, but how this whole criminal law will come into the motion? How this, how that how everyone will start playing their role. Now the basic concept that the police, how will the police will get the information, how the magistrate will get the information, how the courts will get the information about this offense. So that's why this question is important in the introduction of CRPC itself, that how criminal law will come into the motion. Okay, now coming to the answer of this question. I hope the question is clear. I'm just having a look. Yes, Sunita, I'll continue with this CRPC series. Okay. Now coming to how this whole CRPC can come into the motion. So there can be three ways. The first one is through FIR, that is first information report under section 154. The second one is complaint. And the third one is information or suo motu. So these can be the three ways how a criminal law can come into the motion. So let's assume that if someone has lodged the FIR, what after FIR? What after FIR? There is going to be investigation. After investigation, there is going to be police report that is going to be submitted by the police. After police report, there is going to be cognizance taken by the magistrate as per to section 190. After cognizance, the procedure is going to be issue of process. After issue of process, there is going to be charge. After charge, there is going to be trial. Now, let's suppose there is no FIR. Then what? Then there can be case of complaint. And if there is a case of complaint, then there is going to be proceeding of section 200 to 203, which is basically complaint proceedings. After complaint proceedings, the magistrate will take the cognizance. Once the magistrate has taken the cognizance, he will issue the process. Once there is issue of process, after that there is going to be charge. After charge, there is going to be trial. Now let's suppose if there is no FIR, there is no complaint, then what? Then there may be information or suo motu. They may take the cognizance. And if they have taken the cognizance, then there can be issue of process. After issue of process, there are going to be charge. And after charge, there is going to be trial. So this is basically your complete CRPC. This is what CRPC is. This is the jurisprudential essence of CRPC. This is all the functionaries will fit into this one particular chart. So what is CRPC? So CRPC can come into motion by three ways: either FIR, complaint, or information or suo motu. Now you will have a look that this one is the common part. Cognizance, issue of process, charge and trial. See, cognizance, issue of process, charge and trial. Again common. Then there is same here, issue of process, charge and trial. Now what is the difference? What is the difference? Now have a look at the difference. When it comes to police report, you can take cognizance under section 190. On complaint, you can take cognizance under section 190. On information or suo motu, you can take cognizance under section 190. So this is what CRPC is, and these are the ways that criminal law can come into the motion. Any questions? Any question from this chart? Anything which you are not clear with? Yes, please. Okay, Advocate Gaurav Bhaveja. I hope you have liked the classes. Yes, questions, problems, anything which you are not clear with. If it is all clear, quickly give me a thumbs up. Waiting for your comments. Can you please section of cognizance? Can you please section of cognizance as it's not clear? Okay. Thank you, Advocate Gaurav Bhaveja, for the kind comments. Chaliye, okay. Okay, I have got only one question from VR classes. And he's asking, can you please section? Okay. So basically you are asking about section number 190, right? So what is section number 190? So section number 190 is basically telling you that who can take cognizance. First, let's understand the meaning of the term cognizance. Cognizance means of taking judicial notice. Okay. Now, who can take judicial notice? The first answer is judicial magistrate first class. On what judicial magistrate first class is going to take cognizance? The first thing, the police report that is going to be submitted by the police after investigation. That is section 173. Section 173 is basically the police report, and on police report, the magistrate may take the cognizance. So that is the first point. Second, on what else the magistrate may take the cognizance? That is the complaint. Section 2D of the CRPC defined the term complaint. Okay, ji? First thing first. Now coming to the complaint proceeding. Section 200 basically talks about the examination of the complainant. So what is the purpose of examination of that complainant? The purpose of that examination is to make sure that whosoever is the complainant, he is telling the true story to the magistrate. And if the magistrate is convinced that yes, after examination, that the person, the complainant, is telling the true story and that yes, offense has taken place, then he will take the cognizance and will do the issue of process and so on. Okay, ji? So that is again the second one. Now coming to the third one, information or suo motu. Now I'm telling you the difference between complaint and information. So complaint is basically the complainant wants the magistrate to take the action. But when it comes to the information is like, suppose you got a mail with anonymous, or suppose you got a letter which is completely anonymous. We are giving you the information. Now it is completely on you whether you want to take the cognizance or not. Okay, but complaint is something which is like that, okay, I'm the one who is the complainant and I want you to take the action. So that if it's a complaint, you will follow this procedure. And if it's just an information, I am the one who is giving you to the information. Now it is up to you whether you want to take any action or not. Now coming to suo motu. In suo motu, there is no one who is giving you the information. It is you only. Let's take an example. If there is an offense that has been committed in the presence of judicial magistrate, so the judicial magistrate will wait for the lodging of the FIR, or someone to come up with a complaint, or someone to give him the information. No, he can take the cognizance suo motu as well. Okay. So that is basically 190, and it is who? Judicial magistrate first class. But now the question is, sir, can judicial magistrate second class may also take the cognizance if permitted by the chief judicial magistrate? If he is authorized by the chief judicial magistrate, then judicial magistrate second class may also take the cognizance under section 190. I hope I have answered your question. Uh, VR classes? If yes, quickly give me a thumbs up. If not, please come up with another question. Good evening, Shashi and Bablu. Okay, done. Chaliye ji. On that note, let's begin with the next concept. Now, in the introduction itself, you must know that when it comes to FIR, when we are going to lodge the FIR and when we are going to lodge the NCR, what is the major difference between these two concepts? How we are going to decide this is the case of FIR, this is the case of NCR? So FIR is basically under section 154. NCR is basically under section 155. What is the major difference? In cases of FIR, it is the information about cognizable offenses. And in case of NCR, it is a case of non-cognizable offenses. Now coming to the question, how will we get to know that which one are the cognizable offenses, which one are the non-cognizable offenses? So both these terms have been defined under section 2 in the CRPC. So what are cognizable offenses? So there is a list given under schedule 1. Okay. Schedule 1 of CRPC can be divided into two parts. The first part is specifically for the offenses of IPC that has 6 columns, and out of those 6 columns, the one column is about cognizable or non-cognizable offenses. The part B deals with the special offenses. Not special offenses, special laws. Okay, so suppose if there is a dowry act, okay, and in that is if there is any offense, so whether that offense is going to be cognizable or non-cognizable. So the answer lies in schedule 1 part B. Okay, part A specifically deals with IPC. So if it is a cognizable offense, if that is an information of the cognizable offense, lodge the FIR. If there is an information about non-cognizable offense, then lodge the NCR under section 155. Okay, ji. Now coming to investigation, the second part. What is the role of investigation? Students, when it comes to investigation, that is going to be done by the police officer. What is the objective? The objective is simple: to collect the evidences. Who is going to do? The police officer. Now coming to, is it the discretion of the police officer to do the investigation, or the police officer have to do the investigation? So the answer is, in cases of FIR, it is completely the discretion of the police officer. But in cases of NCR, before starting the investigation, the police officer needs to take the permission from the magistrate as per to section 155, and where it is written that it is completely completely the discretion of the police officer to do the investigation. That is your section 156, clause 2. Okay, ji. Now coming to, once the investigation is done, the police will submit the police report, which is also called as charge sheet. So once the police officer has completely filed the charge sheet under section 173, the magistrate will take the cognizance. I have already explained section 190. After 190, issue of process. This is the first stage when the accused will got to know, where the role of summons come in, where the role of warrant comes in, which means now the accused should also get to know that we have already initiated the proceedings against him. So how you can compel appearances of a person in the court? So the basic one is summon. So what if the summons doesn't work? Then there is second, the warrant. What if the warrant also fails? Then there is comes to proclaimed offender. Okay, what if even after that also the person is not representing himself in the court of law? After that, you will do attachment of the property. Once the attachment is also done, you will start the sale. So these are the ways that you can compel appearance of a person in the court of law. So that is basically your issue of process. So once the issue of process is done, then you put charges on him. Okay. So what is the objective of charge? The objective of this whole concept charge is so that the court will get to know, the parties will get to know, the prosecution, the defense, there are only three parties here. First one, the court, prosecution and defense. All must got to know that, okay, these are the charges. If we get to know, okay, this is 302, which means we are talking about murder. So the prosecution know we need to prove that he's the one who has committed the offense of murder. The defense now know we have to defend that this particular person has not committed the offense of murder. And then the court will need to decide at the end whether murder has been done by Mr. A or not. And then there comes the concept of trial. So there is court of session trial. Now, how will we get to know, sir, if there is a case of murder, who is going to do the trial? So we will again follow the schedule 1. And when we are going to follow schedule 1, there is one column which says court trial by. So if, for example, when it comes to cases of murder, the trial is going to take place by court of session. But mark it, when it comes to cognizance, the cognizance will be taken by judicial magistrate first class only. The trial will taken by court of session. So there is court of session trial. So what else? Then there is warrant case and summon case. Now both these terms has been defined in section number 2. What is warrant case? What is summons case? So when it comes to warrant case, any person who has committed an offense whose punishment is more than 2 years, or there is a imprisonment for life or capital punishment, that is going to be treated as warrant case. So this is how we are going to find out whether it is a warrant case or summon case. If it is a warrant case trial. If it is a summon case trial. And the last one is your summary trial. So who all have the power to commit summary trial? Yes, please. Answer in the comments. Who all can have the summary trial? One of the most repeated question you can expect in your exams. So there's a list that has been given. Waiting for your answer. Okay, Chief Judicial Magistrate, CJM, has power to try summary trial or not? JMFC, second class. Okay, so no one has gone through with section number 260. So see, you have to read section number 260, which says Chief Judicial Magistrate, Metropolitan Magistrate first class only in the cases of if he is specially empowered by the High Court. Okay, so they all have the power to try summarily. Okay, now coming to the next one. Okay, any questions till now? Yes, Sunita, correct answer. Okay, moving forward. Now coming to this one, that is the complaint one. So the complaint term has been defined in section number 2D. Okay, so complaint proceedings 200 to 203. So it's like, no, now once the offense has taken place, so if the FIR has not been lodged, can someone approach directly to the magistrate? Answer is yes. Answer is yes. You do have the provision for that. And after that, the magistrate will start the examination of the complainant. And if he is telling the truth, he will take the cognizance. Then he will start issue of process, which means summons or the warrant as per to the case. And then the charge, and after that, the trial. Okay. When it comes to FIR, okay, I have a question for each one of you. When it comes to FIR, I told you it must be cognizable offense. When it comes to NCR, I told you non-cognizable offense. So when it comes to complaint, it can be of which kind of offenses the complaint can be lodged. Yes, please. For cognizable, for non-cognizable, or third option, both. Or D, none of the above. So both A and B, that is cognizable, non-cognizable, or D, none of the above. Answer in the comments. Waiting for your answer. Okay. Sunita and Shreya, both correct answer, that is cognizable and non-cognizable. Okay, when you are going for a complaint to the magistrate, you don't need to see whether it is cognizable or non-cognizable. Okay, both the process is going to be the same. Okay ji. Now coming to the last one, information or suo moto. Okay, when it comes to information or suo moto, this is basically, they are basically talking about that once the information has been given to the magistrate or the offense has taken place in the presence of the magistrate suo moto, the magistrate will take the cognizance and so on. Then he will start the issue of process, then the charge, then the trial. Now I have one important question in relation to this one. So suppose if the magistrate has taken the cognizance suo moto, if the magistrate has taken the cognizance suo moto, just a second, I'll ask a question here. Huh. So if a magistrate has taken a cognizance suo moto, he should transfer the application of the accused to another magistrate, or he should be the one who should continue with all the inquiry and the trial. Yes, please answer in the comments. He should transfer or he should continue with all the inquiry and the trial. Answer in the comments. There's a specific section for this, if you can recall that. Yes, waiting for your answer. Advocate Gaurav Baveja, absolutely correct answer. He may continue, but he need to inform the accused, and if the accused wants someone else, okay, so in that case, he should transfer. Yes, Sunita, correct answer. And there is a famous maxim as well behind this concept, and that is no one can be the judge in his own case, right? So if you know it should not be the concept of suo moto cognizance should not be misused, and this is the reason that there is a concept of section 191 as well. As far as the practical uh, implication of this suo moto cognizance, you will find it very, very few. There are very few instances when magistrates have taken suo moto cognizance. Okay, I'm just giving you this one practical information as well. So that's it from my end, students. Now, anything which you want me to ask, please do write your questions in the comments. So this was basically an introduction, a simple introduction of this subject, that is CRPC. If you have any questions, feel free to write questions. This is your time. This is the opportunity. Anything which you are not clear with, or anything you feel like that is the part of introduction of CRPC, but I have not touched that upon. You may ask questions from that part as well. Yes, please. Waiting for your questions, and if it is all clear, quickly give me a thumbs up. I'll wrap up the session. Exactly, Advocate Gaurav. Completely correct. Nemo judex causa sua. No one can be a judge in his own case. Okay, I have got one question from Advocate Gaurav Baveja. So please explain 2D proviso. Okay. Let me give you one example for this one so you can remember this concept for the rest of your life. Okay. So, students, when it comes to the concept, everyone listen carefully. So, once the offense has taken place, we need to see what kind of offense has taken place, cognizable offense or non cognizable offense. If it is a case of cognizable offense, we will lodge the FIR. If it is the case of non cognizable offense, we will lodge the NCR. In the cases of FIR, the police has the power to investigate without taking permission from the judicial magistrate, which means in this case, if you don't need any permission from the magistrate end. But in case of NCR, as per to section 155, the magistrate's permission is compulsory. The police can investigate only in the cases that when there is a permission from the magistrate. Okay. Now coming to, so this was the concept. Okay. Now coming to an example. Now let's take an example. One offense has taken place and the information has come to the police that this is the as per to the information, it's a cognizable offense. Okay. Now the police officer is doing the investigation because as per to this concept, they don't need any kind of permission. So while doing this investigation, the police officer got to know about this that, oh, it's a mistake. The offense that has taken place is basically non-cognizable offense. So, but they have already lodged the FIR, they have already done the investigation, and after that they have reached to this conclusion that it is a case of non-cognizable offense. Now coming to this, now this non-cognizable, this whole complete case, that once the offense has taken place, after that the information was it was a cognizable offense, and we did the investigation, and after that we got to know that it was a non-cognizable offense. So see, students, in this case there can be now two circumstances. Either it's a genuine mistake by the police, it's a genuine mistake, it can be, or it was intentional. Now, why it can be intentional? Because the police wants to investigate without the permission of the magistrate. That's why they intentionally, make that information as a cognizable offense, and that's why they have investigated and they did whatever they want to, and now they are saying it's a non-cognizable offense. So now the question is, how will we get to know that it's a genuine intentional one? So for this thing, this whole case will police will take to this whole case police will take to the magistrate, and this whole case will be treated as a complaint, and now the magistrate will decide that this is a genuine mistake or intentional one. Why why we are doing this as per to proviso. Now the general rule is that complaint cannot be done by the police officer, right? Because to police it's the FIR, right? But when it comes to proviso, it's the this is the case, then this whole case will be treated as complaint to the magistrate, and magistrate will do the examination and will decide it's a genuine. If it's a genuine mistake, the magistrate will let it go. But if it is intentional, it means you are not following the code of criminal procedure. And if you are not following that, you will be liable, held, the police officer will be held liable for the departmental inquiry and so on. Okay, so this is basically the proviso. I hope now it's clear. Yes, Advocate Gaurav. If it is clear, quickly give me a thumbs up. I'll wrap up the session. So these are the link of my profile, my Telegram channel, and my code Khatri10. So let's crack PCS J with Unacademy. This is the revamped test series, students, for this December. This is the batch which is going to be recently started. Bihar State Judiciary batch. This is the Judiciary Legends UP batch starting from December 15. This is the Plus and the Iconic course. You can use my code Khatri10 to get all the savings. This is a News Students Monthly Current Affair magazine coming soon. These are our channels, YouTube channels. You can join. These all are the Telegram channels of Unacademy Judiciary. So that's it from my end. Gaurav, timing will remain the same, 7 to 8. I'll share the link of the class on my Telegram channel. So Monday to Saturday, the timing will remain the same. Okay. So that's it from my end. See you in my next class.